Appreciate it. Hello, good morning, everyone, and good afternoon in Brussels. Thank you for joining us on a Friday and at the end of the year. I know, especially the topic we're going to touch on today is not a very easy topic for a Friday, but we plan to make it as easy and as fun as possible because it's a very important topic. As many of you know, last Friday, something big happened in Brussels regarding the European Union's proposed EU Artificial Intelligence Act. And we're going to talk about that and explain what exactly happened. And I'm so happy to be joined today by our friend, Vincenzo Tiani, who is a partner at PANETTA law firm based in Brussels. But also a researcher at the Vrije Universiteit Brussels and has been very involved in the policy thinking, policy shaping in the past couple of years in Brussels on the EU AI Act. Welcome, Vincenzo.
Thank you. Glad to be here.
I'll start with the big question. What happened last Friday in Brussels? We've seen many headlines, some of them more confusing than others. Has the EU AI Act passed? Why some of those headlines were referring to white smoke coming out of it? So what was going on?
I even tweeted in Latin, Habemus AI Actum, like we had a pope. Actually, it's true, it's more for the press, because we don't really have a text. We only, the trialogue only agreed on the political part. So for the ones that are not 100% familiar on how the European Union legislative process works, so basically the text was proposed in 2021 in April by the Commission. The Commission is the executive arm of the European Union that proposed, legislations. Then the European Parliament, democratically elected by member states, by EU citizens actually, and the Council of European Union, the heads of state and government of the European Union, wrote their notes, let's say, their amendments, commented the proposal, and then they started some month ago the negotiation that is called the trialogue. So we already knew, we've been, since the beginning, that there were some really hot topic where it would have been more difficult to find agreements. And basically they were the prohibited practices on Article 5, the fundamental rights impact assessment that was introduced by the European Parliament, and general purpose AI. So what we had last week, so first of all, the trialogue started. First of all, it started many months ago. Then this was the last, let's say, shot they had to find an agreement before the end of the year. This is very important because every 6 months there is a different member state that leads the council priorities. This semester was the Spanish presidency, and starting in January will be Belgian presidency, and then in June we will have the new European elections. So basically, even if June seems so far away, actually, it was really the case to close the deal because then we have, the European Parliament, the member of the European Parliament need to start their political campaign, so travel, go to their constituency in their member states, and then there's only time to close everything left, not to really go on with discussions. And this is a very important point because I would say that the fact that the Spanish presidency was so eager to close the deal and to say Spain did it, let's say, helped to stay there for 22 hours straight with no time to go to bed. So this happened on Thursday, from Thursday to Friday morning, and then Commissioner Thierry Breton called a break and say, okay, guys, go to bed, or at least have a break, have coffee, have a proper lunch. And then they restarted on Friday. It was Wednesday until Thursday morning, and then they started again on Friday morning, 9 a.m. until midnight mostly. So it was a sort of Cinderella AI Act.
The Cinderella AI Act, and I have to say I've been following these processes for some good years now, but I don't recall such a lengthy trialogue in the digital space, at least in the digital policy making space. So that was quite something to see on Twitter, X actually, because the commissioners were tweeting from the room, and everybody in the small tech policy bubble, privacy bubble, was following what was happening with this snippet that we were seeing even from far away. Speaking of that, tell me, how's the atmosphere on the ground in Brussels? Are people in the Brussels bubble just talk about the UAI Act? I know there are many other issues out there, but it feels that this was one file that seems to be top of mind for a lot of people. What can you share from the ground of plus looks? And
for sure, there's a lot at stake, and I can tell you that last week I was, let's say, it's December, so it's time for all the final year dinners. I would say that civil society was quite concerned, especially on Thursday, because the situation was quite bad, I have to say. So just to recap, as I said, what was missing yet was Article 5 on prohibited practices, especially the use of remote biometric identification by law enforcement authorities. From what we knew, because even I can tell you that even if I have some phone number of people that were in the room, it wasn't easy to get direct access to information. I mean, they had to work, of course. So the problem, it seems to be that, especially the some member states, France, I would say, so member states that were more struck by terrorist attacks in the last 10 years, I would say, they were the ones that wanted more exceptions for the use of AI by law enforcement authorities. On the other side, and this is another important point, since we are privacy professionals, and this is a big difference, huge difference between GDPR and the AI Act. GDPR was conceived for having the data subject, the people in mind, for giving them rights, and also we already had the adaptation directive, so it didn't come from out of the blue. And it was basically drafted by DG Justice. AI Act is more product regulation, okay, and was drafted by DG Connect. So different kind of approach. So let's say that even fundamental rights were the basis in the GDPR. For AI Act were the exception.
I understand. So
I don't want to oversimplify, but
yes, of course,
I just wanted to highlight that it's a very different approach in drafting the legislation. So what happens that, as I said, it appears that on Thursday there weren't good vibes for fundamental rights. Everything changed on Friday. Perhaps I would say that there were many representatives of the civil society saying, guys, the fact that you have not been sleeping for 22 hours, it's not a good sign. Everything comes up from that kind of work will not be the best, because basically what happens is that you want to just finish, and then this kind of approach could hinder a really, let's say, good negotiation. But on Friday, after a good night, the situation was better. I would say that even the European Parliament was more united, because that's another thing to take into consideration, the fact that of course, let's say Spain has the mandate from the European member states, and the co-rapporteur of the European Parliament, Brando Benifei and Dragos Tudorache, had the mandate from the Parliament, but still they represent someone, meaning that if they are not backed from who they represent, they cannot just decide on their own. And on Friday, the European Parliament was more united in defending, the exceptions on prohibited practices. Also, I would say Spanish presidency wanted to really close the deal. Also, everyone also needs to take into consideration that law enforcement authorities have some, necessities, some needs, and it's not something we can hide. So in the end, there were some exceptions, with exception to the exceptions. The problem is that we don't, of course, we are discussing the acts, but we don't have the final text. So there's still some fear from the civil society that this week there were some public posts, especially from Access Now, saying, actually the kind of loopholes that were agreed, we really need to read the text, because there could be not just small exceptions, but huge exceptions.
And thank you for that, because this is what I wanted to touch on, and particularly for our friends in the US and outside of the EU that are not familiar with the process. They will be hearing about something called technical meetings in the coming weeks. And a lot of people are also wondering, why don't we have yet a text? So we have press releases from the two institutions, the two co-legislators involved. We also have a very useful Q&A document that the European Commission updated in the past couple of days, where there are additional details, but there are still negotiations to happen. So can you share a bit about these technical meetings, what they are, and what are the next steps before we will see a text?
So as I said, last week was agreed, let's say, was reached a political agreement, meaning that on all the principles, on the exception, they agreed on the same, they're on the same page. On the other side, you need to write the text and imagine to really redraft legislation, especially on some specific articles or recitals. It's not something you can do at 3 a.m. with an energy drink,
Yes.
And also there were so many people involved, so member of the parliament, their assistant, political advisor from the group, and the commission. So, and I mean, it's a DA Act. It's not it's not a minor piece of legislation. So now, and until January, the let's say technical, so assistants and policy advisor will beginning again for writing exact words, and so amend the exact words of the Act, and then there will be there will be 2 votes before the final votes. I know, many votes, quite a lot of confusion. So there will be a vote in January in co-rapporteur. Co-rapporteur is basically, it's a sort of it's a committee of the permanent representatives of the governments, and it's not, let's say, a decision-making body, but it's a sort of secretary of the council, let's say. So they're the one that do the job. And then the head of state and government can arrive and say, okay, I agree, yes, I sign here. Then there will be also a vote and so in February there will be a vote of co-rapporteur, and in the parliament, but not the whole parliament, and IMCO Libe. So IMCO Libe are the committees in the European Parliament that been working on the text. So they were the leading committee, as you can imagine. Basically, all over the world, any parliament, not any member of the parliament works on any file. There are split in different committees, and IMCO Libe were the ones that were leading the AI Act. So after that, if everything goes smoothly, and it's still a if, because again, until we don't see the text, anything could happen. There will be a final vote in the council and in the parliament and the plenary in April. So basically, the final text will be delivered in April. It reminds me when you write a draft, and then it's the first draft, and then final draft, and then the very final draft, and then very final draft 1.0. So it's the same. So yes, we don't have an AI Act yet. We have the principles, we have the political agreement. It will be smoother, but still, it's not there.
Still work to done. That's very, very important to clarify.
Yeah.
Well, let's get down to business, as they say, and let's discuss a bit about some of the practical implications of what we know so far. And to be clear, we have enough elements to be talking about this because we have the original proposal. We have, of course, the political agreement in the Council, the general approach adopted by the Council. We have the report of the European Parliament and their negotiating mandate, and details about how all of this came together in the trilogue. This being said, what are the key obligations of this regulation? What is it that it requires of actors in this space to do? And when you're discussing this, I would ask you to also refer to who are these actors. When the GDPR came to be, we learned kind of a new language, right? We learned about controllers and processors and who had what responsibilities and so forth. Who does the AI Act regulate? Who should be worried about it, or let's say care about it? Yeah, I know it's a small question, but give it a try.
Sure. We will have some actors in this play. These actors are the provider and the. Actually, I don't know what is the final term they used. I tried to ask, but I didn't had the proper reply in time, because normally there was the provider and the user, but also this user, it's not the end user we know in other pieces of legislation. So the parliament tried to impose the word deployer. So basically the provider, it's let's say the ones that provide the technology and puts it into market. Let's use let's say OpenAI as an example. They provide ChatGPT, okay, and then you want to use your create your ChatGPT, and you create your I don't know, Vincenzo GPT, where you can ask Vincenzo whatever you want. So in that case, I will be the user / deployer. This means that there are a different load of responsibilities, but since I am the one, the user or the deployer that puts, let's say, on the market to the final, let's say, consumer, the systems, I will be the one that needs to prove, that it was properly assessed and so on. Of course, one issue we had from the European Parliament side was that, okay, in general, we don't want to put all the burden on small medium enterprise or on the startups, because of course the one that are ready, that know there was this huge balance to strike. From one side, we had big companies that said, okay, we are the one that are been developing the AI system that another company will use, based, tailored on their needs. But on the other side, we don't know the final outcome of this AI. So I provide, let's say, the general AI, and then the general software, and then someone else will create something more specific. So, and on the other side, we have small, medium enterprises, startups that wanted to, they don't know everything. They don't know how was the original AI, let's say, that been using, that been tailoring for their needs, developed in a precise way. So they needed the information, and that was the main problem. And of course, there was a sort of they were able to strike the balance, and giving some responsibilities to each actor. Then also, even there are not just provider and user, but also importer and distributor. So basically, everyone is involved in this chain has some responsibilities, because in the end, you are the one that the consumer will know. So it's not just data processor and data controller. Then also we have from the we have the data protection authority. So we go to the governance. We have the third, fifth actor in the play. We have actually two, again, not just one, not just data protection authorities, but we have the AI board and the AI office. So the AI office, it's built within the European Commission. Let's say will be a sort of branch of the European Commission, should be financially independent. They will be in charge, for example, to review the general purpose AI systems. They will provide, of course, assistance to the European Commission and so on. Then we have the AI board. The AI board is similar to the DPP, the European Data Protection Board. So it's in the AI board, there are all the representatives for each national authority. And basically, again, this will ensure that there will be coordination in enforcing and in enforcing the decisions, so that we don't have different approaches in different member states. Bottom note here: the European Parliament introduced, compared to the original proposal of the European Commission, introduced an amendment saying that the national authority would have been independent. Like the data protection authorities are. It's not the case. So this amendment wasn't introduced in the final text agreed last week. It doesn't mean that they will be not independent, because it's still up to the member states to decide in one way or the other. On the other side, I would say that if it's an agency, like we've seen in Spain, in Italy as well, it could happen that if the authority is not independent, the government changes and even the head of the agency change, and that means that even for companies, these could have some minor issues, because you don't know what kind of board in your member states will be in charge for 7 years. Priorities could change from one year to the other, and the approach could change. Again, hopefully, the member states will go in the direction to appoint an independent authority, but we cannot say in advance.
Yeah. I see many questions in the chat. Before, we're going to pick some of them to address live, and the others will try to address in writing after the live. Let's go a bit into high-risk AI systems, because technically providers of high-risk AI systems will have the core of these obligations. Indeed. And then also, if you can briefly touch upon the impact on providers of AI systems outside of the European Union. Should companies in Silicon Valley that now are building AI systems think about the EU AI Act if they want to have EU as a market, which is an if, of course, but big question.
Yeah, definitely, yes. AI Act will, so the scope will regard all the providers of AI system that will address the European market, or where, if in the EU this AI system will be used. So it's like kind of GDPR approach. In your state, we can do whatever you want, but if you want to deliver your system in the European Union, you will need to comply, with the exception of open source. So we will see in a while, basically, if you are using AI only for research, only for internal development, but not to go on the market, so let's say studying, then you are not, AI Act will not apply. But in the end, you will go to the market. So let's say it's better to start. It's better to anticipate that option. So yeah, Article 6. So as for the ones that are totally new, I don't think there is any but. So we have the prohibited AI, we have high risk AI, and then limited risk, and then basically no risk. So high risk AI, we have, for example, medical devices, vehicles, recruitment, and HR, education. For example, emotion recognition was considered another prohibited practice, was considered banned, but only in education and working places. So not a total ban, and not a ban like it was a more extended ban like it was as required by the European Parliament. Then we have access to services, critical infrastructure management, so water, gas, electricity, and so on. Biometric identification, so not remote biometric identification by law enforcement, that is prohibited practice with exceptions, but even normally biometric identification, which we use every day, it's still a risk AI. Law enforcement, border control, migration and asylum is a high risk. Then administration of justice. So in that case, if you want to, if you're a judge, lawyers, you want to use AI to deliver a judgment, okay, you need to be very cautious, and so on. So what you need to do, you need to do a conformity assessment. You need to provide that your AI was trained on proper data and representative data that are not biased. So the example of AI in facial recognition, you need an extensive database, very representative of each ethnicity, gender, possible health problem regarding faces, in order that you can prove that your accuracy is reliable, because you can say that it works on 98% of the cases, but then you could find out that the 2% covers 100% of Black women. Then in that case, it will not work. And then you need to provide, take care of all the logs. So you need to, if we want to compare with the GDPR, it's more really an accountability principle. You need to provide and transparency principle as well. You need to be transparent. You need to be to allow also that the authorities to dig deep in your system in a way that allow that there is no problem, no major issue.
Yeah.
I don't know if it's time to also. I would like to also discuss prohibited AI, but
yes. But before that, I want to ask my colleagues to please drop in the chat a link to our step-by-step guide to a conformity assessment. That's just an introduction, let's say, into these key obligations under the EU AI Act. It's something that FPF and OneTrust published a couple of weeks ago, and we will be updating it once we see the final text. Yes, let's go into prohibited AI systems. What ended up being there in the final list? That's a good question. And then I would like to address at least one or two of the questions. So let's try to keep it.
So for prohibited practices, it's Article 5, as I said, the use of. So one thing is positive. So since the beginning, both Council and European Parliament agreed that social scoring need to be banned. Okay, so if you have watched the Black Mirror episode, the Nosodin, you know what I mean. Then we have biometric categorization systems that use sensitive characteristics, so political, religious, philosophical beliefs, sexual orientation. So again, this is banned. I would use GDPR to ban this, but of course, it's better to, let's say, highlight that these cases are banned. This one, for example, was introduced in the trilogue in a discussion, was obtained by the European Parliament, and it's the untargeted scrapping of facial images from the internet or CCTV footage. We know in the US there are some companies that built this kind of software and also actually sold it to the law enforcement authorities. So if it's untargeted, so basically companies that just use picture and faces from social media and just to not train, but really use these faces for facial recognition will be banned. Emotional recognition. So this, as I said, the ban was partial, so only in educational institutions and workplace, which is already something. Social scoring based on social behavior, AI system that manipulate human behavior and circumvent their free will, and also AI used to exploit vulnerabilities of people. Then there is the exceptions I touched upon briefly before, the real-time remote biometric identification by law enforcement authorities. There are some exceptions. So one exception in the original text basically could have been used by law enforcement authorities with a reference to a list, and this list was comprehensive of crimes that even for 3 years of prisons were in the list. And 3 years of prisons, I wouldn't consider them as a serious crime. So I'm glad that these exceptions was restricted. So we're talking about the search of victims, let's say missing children, missing people. Of course, AI facial recognition can be useful. Prevention of some let's say specific and present terrorist attack. As I said, the terrorism in Europe is still actually, we have a terrorist attack last month here in Belgium, so it's still very vivid. And the localization or identification of a person suspected of having committed some specific crimes, serious crimes like terrorism, trafficking, sexual exploitation, murder, and so on. So better. The problem again, as highlighted by civil society, we need to see the text, because the other thing that could be unfamiliar and for a non-EU audience is that security it's a matter that is addressed only to member states. So in the end, are the member states that decide how to deal with the security issues in their territory. That's why this could be a huge exception, and that's why it requires some proper attention.
Let's go quickly before we close to discuss at least just one point on general purpose AI and this whole section that was included on general purpose AI. And we have a couple of questions in the chat asking about the threshold to consider some general purpose AI as having systemic risk. Yeah. And that threshold is considered to be 10 to the power of 25 flops in the EU. And one of our friends that's live now observes that in the US, this threshold is considered to be 10 to the power of 26. This is one of the thresholds in the Biden executive order, maybe. So do you have any insight as to why the flops were considered, or the amount of flops used as computing power was considered important to decide what's a systemic risk in a GPI?
I would say that, of course, they couldn't, but this is totally personal thoughts. I would say that since you cannot mention specific AI you've been thinking of, you say, okay, that kind of AI that we already know, where is located in the computational power here? Okay, then let's say it's already could be considered systemic risk. Perhaps the Biden administration has done the same. Of course, we are in 2023. Will be the text will be approved in 2024. Then we have 2 years before the proper implementation, entry into force of all the regulation. And perhaps everything in AI could be considered systemic risk for the kind of approach we will have in 2-3 years from now. So I don't know if it was the right choice. I think for sure it was one of the last thing they agreed. And in the end, you need to consider that this general purpose AI wasn't in the original text, wasn't neither in the text that was approved by the council, because the council ended their amendments November last year, and the same month ChatGPT entered into market, and now is what it is 1 year later. So it was really up to only to the parliament to deal with it. Not that the other institutions haven't been thought about it. But again, wasn't in the original text. So it's even more, let's say, difficult to work on something new, something that you haven't thought of, previously. And again, just want to highlight, April 2021, but after already 5 years of stakeholder involvement, writing, research, So it was a long process, and deciding on this kind of AI in in a couple of months, it's not ideal.
Yeah. One last question. Axel asks about fundamental right impact assessments and what did they make it in, and what's the scope? Who will have to conduct one, at least on the basis of the information we have so far?
Yeah. So fundamental rights impact assessment was introduced by the European Parliament, Article 29A, for high risk system. The idea is that let's say having a sort of data protection impact assessment plus, so from GDPR. Also because, personally speaking, I would say we don't know if every AI will be trained on personal data, and the GDPR only applies if personal data are involved. So perhaps it was better to have a proper tool, an independent tool for fundamental rights. So as far as I know, yeah, it was introduced. It was another victory from the European Parliament. But again, we need to see the final text. And the Council already many months ago agreed to have it for having it only for public, let's say AI used in public by public entities. It was the case. Plus, even for AI high risk by private entities, but that they have, let's say, a general impact like banks, assurance, schools, and so on. So not covers all AI high risk, but let's say the one that's even delivered by private entities can have a huge impact on a general audience. For the ones that are not familiar, a couple of years ago, we had a case in the Netherlands, and that leads the government to resign, because this kind of AI was used, algorithmic, let's say, assessment was used to provide benefits to some, poorest family, and it didn't work properly. There wasn't for sure any fundamental rights impact assessment. That's also why the Netherlands is very active, and the academic in Netherlands are very active in, providing a tool to apply it. So that's a good point for fundamental rights. But again, we'll see also what's in the text for this fundamental rights impact assessment. I just want to applaud to the great work from civil society and academia, because also, like, really on Friday morning, there was, and between Thursday and Friday morning last week, there was already 2 letters, one from the academia, one from the civil society, to sustain, to support fundamental rights defense, especially for Article 5. And they gather like more than dozens of signatures, and that were addressed, and a tweet storm, long-lived Twitter, that addressed MEPs and the Commission. So it's important that, even Future of Privacy Forum, all the civil society and academia are involved in this kind of process.
Thank you so much, Vincenzo, for all of your insights. I feel like we should do a series on the EU AI Act and, discuss every bit of it.
Yeah.
There's so much to discuss.
Once we have the text, for sure.
Yeah.
We have many webinars to do.
to be followed. And friends, if you have ideas on what type of analysis you'll find useful, please leave a comment there. We'll definitely look at it. I want to give a shout out to Amalia Bartel. Thanks so much, Amalia, for joining us and following live. I also see Keith from Indiana, who, frankly, Keith, you're mentioning that you're having, as a privacy professional, trouble writing policies for AI and updating our privacy policy to reflect AI. And I think you are definitely not the only one. There's just so much to learn about how personal information is used by various AI systems, and what type of disclosures we have to make about that. And I think this shows the complexity of the technology, but this also shows that privacy professionals have to be involved in the conversation on AI, because we have a lot of our own legal obligations that we need to care about, like transparency, as you're pointing out. That being said, I'm wishing everyone a very nice weekend, and also warm and cozy holidays, and a very happy end of the year to all of you. Thank you so much, Vincenzo. Thank you all.
Thank you.